Well, I'm so pleased to be able to introduce the Honorable Debra Stevens, who was appointed to the Washington State Supreme Court January 1st, 2008, and was subsequently elected to a 6-year term. She had previously served as a judge for Division III of the Court of Appeals. She was appointed and then later elected unopposed to that position in 2007. Justice Stevens is a native of Spokane, Washington, where she practiced law until taking the bench. She attended Gonzaga University as an undergraduate on a debate scholarship and graduated with honors in 1987, and later graduated from the Gonzaga University School of Law as a Thomas More Scholar, again graduating with honors in 1993. Her legal work has been focused on appellate practice with over 125 appearances in the Washington Supreme Court, in addition to appearances in the Washington Court of Appeals, Idaho Supreme Court, United States Court of Appeals for the Ninth Circuit, and as counsel of record in the U.S. Supreme Court. From August 1995 until April 2007, she helped coordinate the Amicus Curiae program at the Washington State Trial Lawyers Association Foundation, which is the longest-standing institutional friend of the court program in the state. She has also taught as an adjunct professor at Gonzaga University School of Law since 1995 in areas including federal and state constitutional law, community property, appellate advocacy, and legal research and writing. In addition, she's a contributing author to the Washington Appellate Practice Desk Book and is known as a prolific writer and speaker at continuing legal education programs. So please join me in welcoming Washington State Supreme Court Justice Debra Stevens, who's speaking on Washington's experience with the ERA.
Thank you, Shanna. And I first have to test whether my technology's good. That's they're taping this, so it needs to have a microphone on. Thank you for coming this afternoon to this program that is part of the celebration of Women's History Month in the Olympia area. And so my point this morning this afternoon is to talk about Washington's experience with the ERA. And I need to be clear that I do not intend to talk about the history of the ERA movement directly, for two reasons. First is that I'm in a room with many women who know far more about the history, having researched it and in some cases participated in subsequent legislative efforts. I, on the other hand, was 7 years old when the ERA was adopted in Washington and have not studied that field. But what I think is equally interesting and what I'm hoping to discuss this afternoon is Washington's experience once, as a state, we adopted a state ERA and ratified the federal Equal Rights Amendment. What happened? And so what have the court cases looked like, and how have we interpreted the ERA to do something in our society, both in legal circles and outside those circles? So that's my goal. I've given a similar talk at a state historical society continuing legal education program where I focused on the leading case in Washington, and believe it or not, it was a case involving girls who wanted to play football. And I'll talk a little bit about that case today, that really the movement toward applying the Equal Rights Amendment in Washington began in Wishkah Valley High School with 2 girls who wanted to play football. First, though, and incidentally, I will have time for questions at the end. Shanna, what time do we need to be done?
Oh, around 1.
Okay, so we'll finish by 1 for those of you who are on your lunch break, and I'll leave about 10 minutes for questions at the end. Let me first give you a bit of the historical backdrop. If I didn't want to terrorize you, I would sing a few refrains of I Am Woman by Helen Reddy, because if you just take yourself back to remembering that era in the early 70s, there was a movement nationally and in many states, including Washington, to recognize equality between the sexes really across the board. not just in the workplace, not just in social spheres, but really I think in the heart, at core, equality, that women were capable of so much more than at least American society had regarded up until that point. In Washington, before Congress proposed the federal ERA, Senator Lois North, a Republican in Washington, introduced a state bill. I think it was in March of 70, it might have been actually first discussed in January of 71, but then introduced in 72, that was close but not identical to the federal Equal Rights Amendment. And in particular, the Washington provision contained a clause that stated that equality of rights under the law would not be denied on the basis of or on account of sex. And then a second provision that Congress would have the power to enforce the legislature would have the power to enforce by appropriate legislation any provisions of the article. That constitutional amendment was proposed in the Senate, was voted on at a popular election in November of 1972, and was adopted by a very slim margin. And I'm trying to recall the exact 50.13% of the voters were in favor of the amendment. Now, the subsequent year, in 1973, Washington also ratified the federal ERA. And you may recall there was an initial strong movement toward ratification. The states that ratified tended to do it very early, and then the movement slowed down, if not died. Congress extended the deadline by some 39 or 40 months, but the requisite number of states never did ratify the federal ERA. Now, how many of you may be aware that there's still a lingering movement that says the ERA could yet be ratified? So there's this three-state strategy that resurfaces every few years on the notion that if Congress can extend a deadline, and it was done with another amendment, the so-called Madison Amendment, that it could yet extend the deadline and the ERA could still be adopted. But in Washington, as to our state rights, it would not matter because we adopted a state provision independent of the federal provision. And it is a part of the Washington state constitution. Now, the text I read you about the proposed amendment as it was presented by Senator North is not the ultimate text that was adopted, because as it went through the legislature to be prepared as a constitutional amendment to be submitted to the people for a vote, the words, a clause, and responsibility was added to the provision, so that Washington's provision reads, equality of rights and responsibility under the law shall not be denied or abridged on account of sex. So that's the provision that we've had as a feature of our Constitution since 1972. Well, before the ink was dry on the state ERA, the issue was in court, because in 1972, the Washington Supreme Court was hearing an equal protection case called Hansen versus Hutt that was ostensibly involving the federal and the state equal protection clauses. The federal equal protection clause under the 14th Amendment, and then a provision that's not textually parallel, but has been regarded as somewhat equivalent, Article 1, Section 12 of the Washington Constitution, which provides that the privileges and immunities will not be unequally distributed. And in that case, interestingly, the court held that the Equal Protection Clause itself regarded classifications based on gender, on sex, with strict scrutiny. Now, for those who are not lawyers, the levels of scrutiny may not appear that meaningful, but in equal protection law, they are critical. So economic type regulation that distinguishes between one class of persons and another based on economics or location or political affiliation, those typically are regarded with the lowest level of scrutiny, a mere rational basis. So if the law has a rational explanation, is designed to serve some rational purpose, and even marginally contributes to that purpose, it will be upheld. The courts will defer to the legislature. Then there's an intermediate level of scrutiny, which is currently what the US Supreme Court applies to sex-based classifications. So the court recognizes that one does not have a choice as to one's gender, nonetheless does not find that gender is the equivalent of, for example, race or national origin, and so only requires a heightened level of scrutiny. There must be a substantial relationship between the goals that are sought to be achieved and the legislation. But strict scrutiny, which is the highest level of scrutiny, requires that the legislation be justified by a compelling interest and that the means chosen to achieve that interest be the least restrictive or most appropriate means to that end. And strict scrutiny, we're probably all familiar that race-based classifications are subject to strict scrutiny. Well, under Hansen versus Hutt, the Washington Supreme Court said that even on equal protection grounds, gender-based classifications are subject to strict scrutiny. Now, why is this important? It's important because there's a footnote in Hansen versus Hutt that says, oh, and by the way, Washington just recently adopted the Equal Rights Amendment, so there. So what we said makes even more sense because, after all, we can't make distinctions based on gender. But in Hansen versus Hutt, the court did not apply the Equal Rights Amendment because that was not the basis of any argument. After all, the amendment hadn't been passed at that time. But I think that sets the stage for the battle of the girls of the gridiron that comes up in then the first Washington Supreme Court case. And that case is Darren versus Gould. The Darren girls were a junior and a senior at Wishkah Valley High School who wanted to play football. They had attended all the requisite practices. The coach testified that they had more than held their own. They were, I think, 5'11" and 6'1", respectively, and they met all the physical and practice-based requirements. But the Washington Interscholastic Athletic Association, the WIAA, had a rule that provided categorically that girls could not participate in contact sports with boys. And so they were not allowed to play football. They had applied for a waiver, and the WIAA denied their waiver. By the way, at the same time their coach applied for their waiver, he applied for a waiver for a boy who hadn't met the number of practices, and that waiver was granted. So the boy was allowed to play, and the girls were not. So they brought a suit challenging the law on the basis of equal protection, as well as the ERA. And in a majority opinion written by Justice Horowitz, the court walks through all of the various reasons that the law might be unconstitutional. It focuses on equal protection, as I mentioned. Article 9 of the Constitution, which provides for education. I don't know if you're aware, Washington has a very strong provision in our Constitution that makes providing a basic education the paramount duty of the state, and also contains a clause that says that the education will be provided without regard to various classifications, including sex. And then finally argued for the ERA. Well, the court talks about the background from Hansen versus Hutt and strict scrutiny, and it talks about the education article and the need to provide equal education without regard to sex classifications, but then turns to the ERA directly and states in pretty categorical language the following. Presumably, the people in adopting Constitution Article 31, which is what the ERA is in the Washington Constitution, intended to do more than repeat what was already contained in the otherwise governing constitutional provisions, federal and state, by which discrimination based on sex was permissible under the rational relationship or strict scrutiny tests. So pause for a moment, because up until this point, if one said that a classification was subject to strict scrutiny, that almost always meant that the law would be invalid under equal protection. It's very hard to survive strict scrutiny. And yet the court says here, the Equal Rights Amendment is clearly intended to do more than what strict scrutiny is already intended to do. And the court concludes categorically that if understanding that strict scrutiny already applied at the time the voters adopted the ERA, then the voters must have meant, and the ERA must mean, that any classification based on sex is per se invalid. So it's a super strict level of scrutiny, almost a strict liability standard that the court follows. But the court recognizes, well, actually, let me elaborate on that. The court states categorically that the ERA renders illegal and outlaw any sex-based discrimination, and that it does so in broad and categorical terms. And then the court says, but we recognize that there are 3 categories where gender-based differences might be allowed in legislation. Number 1, the regulation of cohabitation between men and women. Number 2, the protection of fundamental privacy rights. And number 3, any allowance for differences between the sex that are based on unique characteristics between the sexes. Okay, so those 3 categories, the court says, might apply, but in this circumstance, none of those is at issue because the WIA regulation did not rely on unique characteristics. It just relied on the fact that girls were girls and couldn't play with boys in contact sports without any physical characteristics or other unique characteristics being identified. An argument was made in Darren v. Gould that there was a policy to preserve safety and decorum, and that's why girls were separated from boys. And I think it's important to recognize that an argument could have been made at some level about safety or promoting girls participating in sports by developing girls' sports programs. I mean, we certainly saw later with Title VII, or not just later, contemporaneously, that there is a need to promote girls' sports as co-equal with boys' sports. And a later case that I'll reference deals with that. But the court found that none of those justifications were offered. And so there were no exceptions in this circumstance. So Darren, being the first case to announce the ERA, set the bar extremely high. Not only was the ERA more strict than strict scrutiny under equal protection, but it per se outlawed any discrimination based on sex. Then what happens? I think then we have to recognize that many who were concerned about the effect of the ERA cried foul. They said the sky is going to fall. You know, men are going to marry men and women are going to marry women, and I'll reference that too because 2 of the very significant cases under the ERA, both the first Court of Appeals case and the most recent Supreme Court case did deal with gay marriage. They said, we're not going to have single-sex restrooms, you know, dorms are going to be integrated, you know, where is it going to end? And to some extent, those concerns are validated by the cases that followed, because the cases that followed Darren that were intended to test the limits then of the court's categorical pronouncement range from the ridiculous to the sublime. And I won't go through each of them one by one, but let me give you a flavor of some of the what I'd call more of the ridiculous than the sublime. Because right after Darren v. Gould, just a couple years later, a group of topless dancers challenged the Washington State Liquor Control Board regulation that limited the distance that topless dancers had to maintain from patrons. And they challenged that violated the ERA because the law only prohibited women topless dancers. That's a case called Bolser versus Liquor Control Board. In a similar case, a group of women in Seattle, Seattle versus Buchanan, the same year, challenged a Seattle city ordinance that prohibited the exposure of women's breasts in public. And of course, the argument in each case was, well, men can expose their breasts and they can get as close to patrons as they want, and men can expose their breasts in public in the park, and that violates the ERA. And I think sensing that taking the ERA in this direction would perhaps trivialize the gains that it was intended to achieve, the court retreated a little bit and said that the distinctions really reflected unique characteristics to one sex, that although men have breasts and women have breasts, they're fundamentally different things. And the court doesn't elaborate on why that's true, but just says it because we all know it's true, that those are fundamentally different things and are associated with different things. And therefore, the regulation doesn't impermissibly classify. Another similarly more ridiculous than sublime case dealt with a challenge to ladies' night at the Seattle Sonics games. And in this case, a man who went to the game with his wife complained that he was able to get a half-price ticket for his wife, but he had to pay full price, and that was discriminatory in a public facility on the basis of gender. And in an opinion that had no precedential value because no majority of the court signed any particular reasoning, the court says essentially, oh, come on. You know, this isn't the type of discrimination the ERA was intended to address. And secondarily, you saved money. Your wife got a half-price ticket, so the community benefited anyway. So I don't attribute much to that case as far as developing the ERA. But now let's go to the more important cases that really did help advance the ERA. Because if you think about the categorical line in the sand that was drawn in the girls' football case, the next challenge that really took the court in a different direction analytically was an affirmative action type of challenge. And that was in a case called Marchiori versus Cheney. And there were state statutes at the time, and I wish I knew this was a 1979 case, so Senator Frazier might even recall when the statute changed. But at the time, the state statute required that the chairs of the state Democratic Party or Republican Party and the caucus chairs, the chair and co-chair had to be one man and one woman. And so it did not, for example, allow two women in the leadership or two men in the leadership. There had to be one man and one woman. And that was challenged, obviously, as violating the strict prohibition about classifications because it differentiated between persons solely on account of sex. And for the first time, the court then looks at not just the language on the surface of the ERA, but the historical purpose of the ERA. And it makes a distinction that was nowhere foreshadowed in the girls' football case about the need to draw distinctions in order to rectify evidence of past discrimination and achieve equality in fact. And so the court upholds the statutes as valid, rejects the constitutional challenge on the reasoning that if there is an equality in fact between the representation of men and women in the leadership, that's designed to promote and not defeat equal rights between the sexes. And the court says, quote, the ERA simply does not apply to this type of situation. A four-justice dissent, so that was a 5-4 opinion, goes back to the Darren decision itself. And notably, the dissent is written by Justice Horowitz, the author of the Darren v. Gould girls' football decision. And he says, I think somewhat appropriately to the text at least, where does this come from? He says, this is nowhere what we talked about with strict scrutiny. But I do think that consistent with the notion of affirmative action law as it developed under equal protection law in race discrimination cases, the court was really on the right track in signaling that if the purpose of the ERA was to achieve equality between the sexes, then statutes that are designed to rectify inequalities cannot be invalidated simply because they recognize what in fact exists, which is that history or pattern of inequality. So that was, I think, a very significant case in advancing the ERA beyond the initial backdrop. It wasn't until later that the court, in a very significant case called Guard v. Jackson, revisited the exceptions that it recognized in the Darren case. And let me talk a moment about Guard, because Guard involved a statute that I have to say, to me, in 2010 seems inconceivable. But virtually every state had this statute. We have laws in most states that allow parents to bring a lawsuit when a child is killed, the wrongful death statutes. You may or may not know that at common law, so in the absence of a statute, if if a person dies as a result of another person's negligence, there was no cause of action. No one could bring the action on behalf of the deceased person. And so the common law notion was that it was, frankly, better to kill your victim than to seriously injure your victim, because that would support a lawsuit for liability. But statutes were developed, wrongful death and survival statutes, that allowed certain persons to bring claims on behalf of a deceased person. And this statute in Washington provided that a father of a child who had acknowledged paternity, but in a divorce situation or a no marriage situation, and was not currently paying child support, could not bring a cause of action. There was no similar limitation on a mother's right to bring a cause of action. So even if the child had been removed from the mother or was living with relatives or a ward of the state, the mother could bring the action regardless of whether she was paying support, but the father had to be paying support. And in Guard v. Jackson, a father who was dismissed from a lawsuit challenged that statute on the basis of the ERA. The Court of Appeals found that the provision did violate the ERA, and then the Supreme Court looked at it. And in a unanimous decision, and this, I didn't tell you the year of this, I think it was also, it was 1997, so this is much more recent. So again, that takes me back when I think this statute existed all the way until 1997. But the court identifies it goes back to the ERA and looks at the reasons for the classification, and it recognizes what the court had previously said in the Marchioro case about rectifying past discrimination and recognizing the need for equality in fact, but finds that that is not at issue here, but that the exceptions that had been identified in the ERA, remember you could prevent cohabitation, unique characteristics to one sex, and privacy, that those were overbroad. And instead it articulates really just two exceptions that the court would be willing to recognize. And these are the exceptions that I think endure today in how we look at the ERA. And those two exceptions are, number one, to rectify past discrimination. So the affirmative action sort of notion carries forward. I mentioned the Democratic Party case with Marchioro. A subsequent case had dealt with preferential contract preferences to minority and women-owned businesses in state public works projects, and the court also upheld that differential as based on an affirmative action type notion. And then the second one the court recognizes is when there are actual differences between the sexes that justify the classification. And clearly it doesn't find that applicable. But notably, privacy concerns go out the window. Regulation of cohabitation, which I think really was a relic of the late 60s, early 70s. I think it was laced in there to quell the fears of unisex dorm rooms or something. But it really was never brought to the surface again. That goes by the wayside. And what the court emphasizes is that the public policy is the ERA. So yes, you could talk about a public policy of privacy, or you could talk about a public policy of morals and decorum and the education of children in single-sex dorm rooms, et cetera, but that those public policies can't override the policy that's articulated in the ERA itself. So unless there is a characteristic unique to the sex, so really a scientific, factual distinction between men and women, or a necessity to rectify past discrimination, then the exceptions would be absolute. Along the way to getting to this holding, I do have to mention, I mentioned Title VII and the need to develop women's sports. And along the way in this path of cases, the court did reject Washington State University's attempt to have unequal funding between men and women's sports. And any WSU grads in the crowd? Or okay, one WSU. I'm from Eastern Washington, and of course my husband was a WSU person, and football's a big deal at WSU. And so as this case was postured, what the lower courts had done was said, of course the ERA requires there be equality between men's and women's sports and the funding, but we're just going to exempt football. So you just take football out of the equation, and then if everything else is equal, we're all square. And I love the quote in the in the Washington Supreme Court opinion. It says, "We believe it is stating the obvious to observe. The Equal Rights Amendment contains no exception for football." So the court required them to throw all the sports into the mix. Last set of cases I'll comment on. I mentioned that one of the fears, when the ERA was first being discussed, which was in Washington, the state amendment was first discussed in late 1971, proposed in 72, adopted later in 72. One of the fears was that it would require recognition of gay marriage. And interestingly, the very first case to test the ERA in the lower courts, it never got to the Washington Supreme Court, was a case called Singer versus O'Hara, which was a challenge by two men who wanted a marriage license and were not issued a marriage license. And the Court of Appeals held, in a fairly short opinion, that the denial did not violate the Equal Rights Amendment because the law applied equally to both sexes. Both sexes were required, in other words, to marry a person of the opposite gender. And the reason I mention that case, so that's Singer versus O'Hara, is the most recent case in Washington, which was in the Washington Supreme Court to address the ERA, was also a gay marriage case, and that was the Anderson versus King County case. And maybe you're familiar with that case because it was very controversial at the time and contained multiple split opinions by the Supreme Court. It was a 2006 opinion. And there, a majority of the court, comprised of two separate opinions, but they agree on the reasoning, essentially agreed with the Singer versus O'Hara Court of Appeals opinion and found no violation of the Equal Rights Amendment in the denial of marriage licenses to homosexual couples, again, because it was equally applied. No man, or each must marry a person of the opposite gender. The dissenting opinion, which was written by Justice Bridge, said in contrast that there is a gender-based violation because, and I quote the dissent, "Under this law, a woman cannot marry the woman of her choice, though a man can marry the woman of his choice." And so it really depended on the characterization. But the result of the Anderson versus King County decision was to uphold the state Defense of Marriage Act, which was what was being challenged at that time. So I think it's interesting that we came full circle, that the earliest lower court opinion to challenge the ERA was a gay marriage case, and the most recent opinion under the ERA was also a gay marriage case. What my goal was in just rehearsing these cases for you was to show that Washington's experience with the ERA is really much more than the history of the adoption of the ERA, because once the text is there, what states do with it really makes all the difference. And Washington, I think, is really one of the states that more than many others has used the ERA to impose the highest level of scrutiny on laws that have gender-based classifications. So not only is it strict scrutiny, but it's essentially an absolute per se prohibition on sex-based classifications, with only those two exceptions I mentioned that remain. Number one, if the classification is designed to alleviate prior evidence of discrimination, it doesn't implicate the ERA. And number two, if the classification reflects, in fact, differences between men and women, then it doesn't violate the ERA. But beyond those classifications, it's regarded as one of the highest policies of this state to recognize gender equality between men and women. And beyond even direct constitutional challenges, the ERA has been used as a powerful source of public policy. For example, in the employment context. So we have a cause of action in Washington. It's called the public policy tort, where although an employer can fire an employee for no reason or any reason, you cannot fire an employee for a reason that contravenes a clear mandate of public policy. And the ERA is recognized as a clear mandate of public policy. So even outside of a direct constitutional challenge, it has implication. And let me just, I want to take questions, but let me just observe this, that, I came to the ERA obviously not from direct experience because I was in second grade when it passed, but I think I grew up with the benefits of it, in that I compare my experience in school and then later in college and entering a career against the experience of my mother or my aunts or just women who are not that much older than I am, maybe 5 or 10 years. And I think the recognition of women's equality has done, the legal recognition has done so much to open the public, expose prejudices, open the public dialogue, and really instill in my generation and the women after my generation, a greater confidence in all the things women can do. And I think an appreciation of what options that gives us. I do not find that the ERA has been the answer to pay inequality or the success of women in the workplace. I mean, I know more about just the legal profession than the business world, but in the legal profession, we have a very large number of women who enter the legal profession. You may know that most law schools, 50% of the students are women. But if you fast forward to maybe 5 years in practice, and then you look at the number of women who become managing partners of law firms or who move up the scale, the numbers are no better now than they were 25 years ago. It's dismal. The number of women who leave the practice of law or who go into part-time practices or government practices, it's still startlingly bad. And so I think the message that tells me is that clearly the legal recognition is just the point of entry, and what we do with this and how we shape the culture is really what's going to make the difference. So with that, I'd welcome any questions or comments. Yes?
Was there awareness of this aspect of the legal profession, the ERA, and the law, a part of the motivation that sent you to law school?
Well, that's interesting. I think so. I think it was more subtly probably through my mother, because I grew up in a family where my mother, just for economic reasons, she was very, very poor and she was orphaned at a young age, never had any opportunity to get an education, and she always encouraged us, that we could do anything. I'm one of 5 daughters, and all of it, so that helped too. Men were really quite irrelevant in our household. with that many girls, of course you could do everything because you had to do everything. There was no one else to do it. So yeah, I do think so. I remember one of my earliest memories was that my mother had it was a gift to her actually from her mother-in-law, from my grandmother. She had one of the ERA promoting posters. Remember a woman without a man is like a fish without a bicycle, and that always stuck with me. That sure, sense of empowerment. Sir.
Well, as you indicated, the peak of activity about putting the ERA in place was in the 1970s. And when I think about it, my colleague, it's shocking that that's 30-something years ago. And during that time, American society has gone on and generated various cases that involve sex discrimination or not. And I wonder, when you think about what an in-place ERA on the national level might have done, can you think of any cases that might have been decided in a different way had there been an ERA in place?
I definitely can, because the most active area of sex-based discrimination litigation that went to federal courts was pay equality. And of course, this after President Obama was inaugurated, one of his first acts in office was to sign the so-called Lilly Ledbetter legislation. That was a woman who suffered really gross pay disparity for her whole career and wasn't allowed to sue. But I think the ERA would have made a difference in those early pay cases because there was a plurality opinion, which means not a majority, a 4-justice plurality in a U.S. Supreme Court decision called Frontiero versus Richardson in 1972 that would have recognized sex-based classifications were subject to strict scrutiny, would have treated it the same as race-based classifications. And that's the view that Washington did adopt in the Hansen versus Hutt decision, but almost immediately, within 2 years, the Supreme Court retreated. and found that pay disparities were rationally related to job descriptions or expectations or any number of things. So I do think it would have made a difference. I think it wouldn't have been the final answer in that we saw in in race discrimination cases, for example, which are subject to strict scrutiny, that, what was the next wave of race discrimination cases? After we had the cases that guaranteed race equality for minority populations, what we saw were the reverse discrimination cases, the Bakke versus University of California type of cases. And I think the same thing has happened with gender equality, that it's not an accident that many of the ERA cases were brought by men. So, but I do think it would have had a concrete difference, especially in the pay disparity cases. Yes, sir.
What year again did you say was the Darren Wishcott football case?
I think the decision was, let me double check the date. It was shortly after the ERA. Oh, well, here, I have it right here. 75. So the decision came out in 75, but it was it was being litigated when the ERA passed. So by the time they filed their complaint, the ERA was newly enacted. I think the complaint was filed in late 73 or early 74.
And the girls were juniors, sophomores and juniors?
Right.
Okay.
So it was clearly moot. By the way, that's one of the things we deal with a lot in the law is by the time a case is decided, they're in college, they don't really want to play football anymore. But it's a recurring issue, and so the court can address it at any rate. You may recall that in the abortion cases, one of the reasons the Supreme Court avoided hearing an abortion case for a long time was that they could always use mootness. It was done by the time the case would ever hit the court, and so we've crafted exceptions to that. Yes?
I remember when I was campaigning for the state ERA, I was working hard on an attorney friend, and that person told me he was concerned that the ERA would cause the court to be clogged with cases. And I don't think that turned out, and from your description of the cases, it sounds like there have been some intermittent ones, but that's kind of it.
True. I think there was early activity sort of testing the limits, and a lot of those cases I kind of described as trivial, ladies' night and nude dancing, those kind of cases went away pretty quickly. There were just a handful. But since then, since about 1978, there have only been a handful of cases, and they tended to be quite significant. So they were like the Guard v. Jackson case challenging the statute on wrongful death, or Southwestern Contractors case challenging contractual preferences in public works. So no, it hasn't flooded the courts, and I still see men's and women's restrooms. Though not at the University of Washington. I noticed that I was there recently, and it's just restroom. And you kind of peek around the corner, and you choose your portal, I guess. It's kind of a... But, I mean, I think a lot of those fears were grossly overstated. Yeah. And interestingly, too, it hasn't been the answer to the gay marriage debate. And I think that reflects that debate can be characterized in one of two ways. I mean, I read you the quote from Justice Bridges' dissent. She says, this is clearly an ERA problem because a woman can't marry the woman of her choice, but a man can marry the woman of his choice. Whereas the other side says it's clearly not an ERA problem. Neither a man nor a woman can marry a person of the same sex. So I think that shows that the ERA can't be the answer to the gay marriage debate. That's really a social and policy-based issue that has to be, that I think, as a justice, I think is obviously much better decided in your line of work. It's really, it's a public policy issue that needs to be openly debated and determined outside the courts. Yes?
I have two questions. One is, I wondered if there's case law on clothing, because I seem to recall that when it was passed, all of a sudden, women girls in school could wear pants to school. I seem to remember that.
It was
right in that era.
The cases I'm thinking, I mean, in Washington, no, I can't think of any case. There are cases on not having clothing. So to the extent there are cases on clothing, it's that you must wear clothes. But other than that, no. Though I do, I should point out, this may come as quite a surprise, but in maybe 10 years ago, I lose track of time, but when I was involved with the Washington Women Lawyers, I was on the board, there was an uproar about a judge in Seattle who was subsequently defeated in her re-election campaign, who sanctioned, as in contempt of court type sanctions, 2 women attorneys who appeared in her court in pantsuits, something like this, because they were not wearing skirts. Yeah, and that was, in the late 90s. But like I said, we elect our judges in Washington, and that took care of itself. Yeah, sir.
How much variation across states is there on this subject?
Good question. There's great variation. Even among states that had ratified the federal ERA, how it is construed varies greatly. Washington is clearly at the high water mark. I mean, the strict scrutiny, super strict scrutiny, per se, categorical language is as strong as it gets. Many other states look at it as not much more than equal protection analysis, and so they find classifications must be substantially related, but they do make any number of exceptions. Yes?
Have there been any federal cases that make the national ERA in effect, or kind of put it into effect to a degree?
I can't speak with absolute certainty because I haven't researched that. I think in many ways, one of the things that came out of the ERA that has rendered the constitutional provision less significant nationally and at the state level is the fact that legislation that followed codifies principles of the ERA. So in Washington, we have a very strong law against discrimination. Of course, we have very strong civil rights laws nationally as well. And so most of the litigation I've seen that is ERA-like, I mean, gender discrimination type cases are statutory more than constitutional. And there's a practical reason. I won't bore you with all the specific details, but the very practical reason has to do with remedies. To bring a constitutional challenge, if you're trying to do something other than send a message, you prefer to use the statute because the statute gives you back pay and front pay, and in the federal case, punitive damages and attorney's fees, and it really makes it possible to bring these claims. To bring a constitutional cause of action is very much an uphill battle, and there are no provisions necessarily for attorney's fees, and there's qualified immunity, and so I think that's why you don't see it. I think it's far, a lawyer who really wants to do some good for her client is going to bring a statutory claim where the client really sees something, sends a message and sees something at the end of the day. And most of the women, I did a fair amount of, what I call kind of abuse of power type of litigation, and usually under Washington's law against discrimination or similar employment statutes. And my clients always believe, the best way to send a message is to get some money out of a person. And so, it can reflect the policy of the Constitution, but one of the great things about the policy of the Constitution is it led to very good legislation. Yes? Go ahead.
I've heard 2 things about at the federal level, because we don't have a federal ERA. One thing I've heard is, how about the Equal Protection Clause? Shouldn't that cover all of this? And then I've heard others say, well, it doesn't quite do it, but then there's a proposal for a federal statutory ERA. And do you have any comments about how effective that would be compared to a constitutional ERA at the national level?
Yeah, let me break it down into 2 parts, because you mentioned that you've heard that the equal protection versus the ERA doesn't really matter. And as I answered it to the earlier question, I think it does matter. I think equal protection analysis in the U.S. Supreme Court since about this era forward hasn't been all that protective of gender-based classifications. So I do think it would do something qualitatively different at a constitutional level. As far as the statutory versus a constitutional difference, some of it goes to the comments I was just making about just the practicality of remedies. And so I think we do have some very strong legislation, but it tends to be context specific. So we have very strong legislation in the employment context and very strong legislation in the education context. But as to some other, and public accommodations, you know, there are provisions that relate, you know, think of how far we've come with disability accommodation, but also for equal protection in public accommodations. So the argument might be made that if you had a constitutional provision that would sweep more broadly, and certainly it would, but bear in mind that we, for the most part, actually I can't think of any exceptions at the federal level, a federal constitutional provision is only enforced where there is state action. You know, for example, I can't come after you for violating my First Amendment rights, for example. If you say, sit down and shut up, Debra, I can't bring a First Amendment claim. If my government says, sit down and shut up, I have a claim. So that state action requirement being there, I'm not sure that I think a pure constitutional claim would necessarily be more effective than the legislation. The one thing I do take a step back and say this, though. It's a shame that the ERA movement slowed down. And I think there is just a public attitude about gender equality that would be very different if the ERA passed. And so I'm not, you know, out crusading every day, but I still think to keep the movement alive and the discussion alive is useful because women in the subsequent generations, and I mean, I have a daughter who's a sophomore in college, and we talk about her experiences. You know, gender inequality is alive and well in so many different areas. And so I think to the extent that the ERA passage, ratification of a national ERA would spark people, and I think that's valuable in and of itself. Even if it just led to better legislation and never resulted in a single victory in court, it would send a powerful message.
So do you think a national statutory ERA would do that, or is that?
I think that could be useful. You know, the problem, of course, the fundamental difference between a statute and a constitutional provision is that it's a lot easier to change a statute than it is to change a constitutional provision. But with that caveat, I think a statute would be a step in I think it'd be a very positive step.
Thank you so
Great.
much.
Thank you for having me. I enjoyed it.